Good evening, ladies and gentlemen. Today we have with us Professor David Yamada. Professor David C. Yamada is a professor of Institute at University Law School in Boston, a globally recognized authority on workplace bullying, mobbing, and abuse. He has authored leading law review articles on the topic, as well as model anti-bullying legislation such as Health Workplace Bill. His Minding the Workplace blog is a popular source of contemporary on work, workers, and workplaces. David is also the founding board chairperson of the International Society of Therapeutic Jurisprudence and author of a comprehensive survey of TJ. Therapeutic Jurisprudence Foundation Expansion and Assessment forthcoming in the University of Miami Law Review. David has earned his Juris Doctorate degree from the New York University in 1985. We are delighted to have you on board with us here today as the speaker for the session, sir. Thank you so much for joining with us.
Thank you so much for this invitation to participate. I know that many of you are logging on to this event in the midst of a very difficult and challenging public health crisis. And so the fact that you would spend some time with us here today really means a lot. And I hope that I can contribute to making this worth your while to be part of the event. I know this is part of a larger series on lawyers as peacemakers. And so the piece that I want to talk about and share with you is coming from the field of therapeutic jurisprudence. I don't know how much introduction you've had to TJ, as we call it, but therapeutic jurisprudence is a field of theory and practice that was founded in 1987 by American law professors David Wexler and Bruce Winick. And in essence, therapeutic jurisprudence says that we should look at the law's capacity to be therapeutic or anti-therapeutic in terms of its impact, its results, and its outcomes. TJ implicitly values outcomes in legal proceedings and events that embrace psychological health, human dignity, and well-being. And so obviously, those kinds of qualities really do resonate in terms of where we are today, not only with this public health crisis, but with so many other things that are surrounding us in the world today. My focus over the last 10 or so years has been to help create a discussion about therapeutic jurisprudence in terms of scholarship, in terms of building it as a field of study, theory, and practice, of helping to frame this body of work in a way that is accessible and useful to scholars, students, practitioners, judges, not only in the United States where I live in Boston, but in the world. And so it's a real delight to be able to share some of that work with you. In particular, I've been focusing on applications of therapeutic jurisprudence to the world of public policy. Now, TJ has long been associated with core subject matter areas, such as mental health and disability law, criminal justice and criminal law and procedure, as well as problem-solving courts. A lot of that work has been more litigation-oriented, looking at applications of TJ to standard brand lawyering skills in a more therapeutic and humanistic way, as well as designing alternative dispute resolution processes whereby legal disputes can be handled in a more therapeutic way, such as through problem-solving courts that divert those being charged with misdemeanors into non-custodial resolutions that promote rehabilitation and healing, as opposed to, at least in the United States, continuing the over-bloated pipeline of human beings into our criminal justice system. The perspective that I'm suggesting for TJ is a little bit different in focus. It's looking at law, legislation, regulation, administrative pronouncements, executive pronouncements, as public policy and asking very similar normative questions. In other words, how can public policy be therapeutic, um, advance psychological health, human dignity, and well-being? There's another question connected with that, and that's a more procedural one. And that is whether public policy processes, in other words, the stuff of which legislatures and executives and administrative agencies operate, um, are those are those processes therapeutic, anti-therapeutic, or some mix? In other words, are significant stakeholders given sufficient voice, validation, and voluntary participation through the policymaking process? I'm starting to call that legislative due process, even though that's a very invented term, because there is no such thing, at least in the United States, as legislative due process. So again, to summarize, it's a two-part inquiry. First, are public policies themselves producing outcomes that are therapeutic, anti-therapeutic, or some mix? And also, are the processes of government and regulation therapeutic, anti-therapeutic, or some mix in between? And I want to give out some examples of how we might use this very simple framework to think through these types of questions. The first example I give is a very positive one, and that is in 2019, New Zealand adopted what they called a well-being budget. This was under the leadership of their Prime Minister, Jacinda Ardern, and the New Zealand well-being budget explicitly stated that the goal of our national budget is to advance individual and societal well-being. And the whole budget document, I think it was over 100 pages, something like that, was designed to identify not only the public policy objectives, but the ways in which those objectives might be measured and evaluated. It was quite a revolutionary document, in my opinion, because even though a lot of the programs and funding lines and so forth that were contained in that budget document are not unique in terms of being the kinds of standard content that one sees in national budgets. But what really distinguished that document was the national government's pronouncement that our overarching policy outcome goal is well-being for the people living in our country. It was noted not only in New Zealand, but by commentators around the world. I hope that more governments will look at the New Zealand example and be inspired by that. But in any event, I thought it was a wonderful, positive affirmation of how public policy can be explicitly embracing of well-being, psychological health, the public good, in ways that oftentimes are not reflected in the way we talk about public policy. By contrast, I want to talk a little bit about what things have been like in my home country, the United States. While things are changing now, I genuinely believe they are changing under our new president, Joseph Biden. As most of you know, in the US, we have been through a really difficult time with his predecessor. And there are two aspects of public policy among dozens that I could cite that were focal points of the administration of Donald Trump, which to me highlighted the anti-therapeutic applications of public policy. And they are only two of the countless examples one could give. The first example I want to give is that of our nation's immigration law enforcement. In particular, the fact that the Trump administration vigorously applied a child separation policy in which undocumented individuals or families experienced the anguish, the horror, the just terrible heartbreak of being separated from their children, parents separated from children. We are still trying to reunite those children with those families. So that's how difficult this process has been. To me, it was one of the most profound human rights violations that my country has committed over its several centuries of existence. In a writing, I compared the child separation policy to stories of American slavery, whereby in slave auctions, families were separated by sale because they were deemed to be basically retail objects to be sold for labor. And so you'd have children and parents and husbands and wives and families ruthlessly split up for purposes of being used basically as chattel. Well, maybe the separation of families at the border circa 2018, 2019 is not quite as brutal as the story of American slavery, but it definitely has echoes of that kind of insensitive, well, more than insensitive, just plain inhuman and cruel treatment of other human beings. And so I thought that was such a contrast to the way in which, let's say, New Zealand was saying we are embracing the well-being of everyone in our Commonwealth. And the United States is saying, you know what, you don't have the right papers. We're going to split up these families and we're going to try and send some messages. And the human wreckage is just, you can't overestimate the pain and trauma caused by that kind of application of public policy. The second example I wanted to give from the US is the way in which we've handled, or in some cases mishandled, healthcare. During the Trump administration, or I should say the Trump administration, engaged in repeated legislative attempts to repeal the Affordable Care Act, which is a major legislative package that was enacted under the Obama administration that finally started to close our gap of people who were uninsured, not covered by health insurance. Over and over and over again, the Trump administration went to Congress using different devices to try and repeal the Affordable Care Act. Had that legislation been successfully repealed, it would have left millions of people without health insurance. For many years prior to that, Donald Trump had promised that he had, basically in his back pocket, some miraculous plan that would improve on the status quo of American healthcare. And that's why we should get rid of the Affordable Care Act, because he had something better that he was just days or weeks or months of pulling out of his hat or his back pocket. Well, we know that was not the case. The repeated attempts to repeal our primary national health care law were not supported by any alternative legislation to fill the gap that would have been created by the repeal of that legislation. They weren't successful in fully repealing the Affordable Care Act. However, and this is where I get into what I call the legislative due process piece of it. The blitzkrieg of attempts to repeal this statute without hearings, without taking into account stakeholder feedback, really did terrorize those whose health care was dependent upon the mandates of the Affordable Care Act. It meant that people had to turn on their televisions or check into the internet, listen on the radio, and not know whether the next day the law that provided their health care would suddenly be no more. Over and over and over again. So even though it was an unsuccessful set of repeated attempts to repeal our health care law, the fact that those who were dependent upon that law had to sit through weeks and months of repeated attempts to, in essence, take away their health care was frightening and traumatizing. And so when public policy fails to give people that voice and validation and voluntary participation, the result can be a traumatic experience in and of itself, from fearing what's going to happen when you see certain things that you're depending on to live being at the brink of being taken away from you. As a little side note, I want to mention or focus on the phrase I just used: voice, validation, and voluntary participation. The 3 V's. This comes from a concept pioneered by Professor Amy Ronner at St. Thomas University Law School in Florida. And Amy applied these precepts of voice, validation, and voluntary participation to legal proceedings. But I found it really useful to apply to legislative process as well, right? Because if those of us as citizens, as residents of a given nation or a given municipality or community don't have voice, validation, and voluntary participation, then that diminishes our dignity as stakeholders in a society. But it also means that we may lack the ability to have input into the legislation, the regulations, the public policies that affect our lives and those of others. So I was happy to graft Professor Ronner's litigation-oriented concept of voice, validation, and voluntary participation into the world of public policy. A third example I'd like to give is work that I've been doing for many years, and Muhammad was kind enough to mention that as part of my introduction. My main focus of work as an employment law professor has been to advocate for the creation of legal protections against workplace bullying, mobbing, and generic abuse in the workplace. At least in the United States, this is a huge gap in our employment laws. We have fairly good protections against employment discrimination on the bases of categories such as race and sex and color and national origin, age, disability, religion. We have recently added sexual orientation and sexual identity, gender identity to that list. But if somebody is being harassed and mistreated at work for reasons that are unconnected to those protected class statuses, then they very well may fall between the cracks of existing employment protections. This may include verbally abusive behavior at work, such as a boss who is constantly yelling and screaming at an employee and making their life very miserable and anxiety-ridden. It can also include behind-the-back behaviors to try and sabotage someone's work or reputation for purposes of undermining their livelihoods, undermining their careers, and chasing them out of a given workplace. So back in the late 1990s, I started researching protections that might exist against bullying at work and found that the existing protections were not adequate. I drafted model legislation called the Healthy Workplace Bill that is now being considered in various state legislatures in the United States. We haven't been able to enact the full version of it yet in any given state, but a smattering of states have adopted kind of watered down versions of this legislation to create some minimal obligations of employers to try and act preventively in responding to the problem of bullying and mobbing in the workplace. That's the little summary of the substance of what I've been working on. I think it really fits into this this paradigm of looking at legislation through a therapeutic jurisprudence lens. In other words, creating protections for workers against workplace bullying, mobbing, and generic psychological abuse at work advances psychological health, advances human dignity, and promotes individual as well as organizational well-being. I have seen over the years the suffering of so many people who've experienced this form of mistreatment at work. And on some occasions, in fact, there have been suicides associated with workplace mistreatment of this nature. Now, as we know, suicide is a very complicated topic. Issues of causation are rarely limited to a single reason. It's oftentimes a confluence of factors that may contribute to someone taking their own life. However, we also know that there can be events that might push someone over the limit. And that's the kind of thing that we've been looking at in some of these severe instances of bullying and mobbing in the workplace. So that's a piece of what I've been working on that's been consistent with this legislation or consistent with this legislative framework. The last thing I want to mention is what we are experiencing now, and that is to ask whether our public responses to the COVID outbreaks as public policy, as healthcare, as public health policy have been sufficient. And I don't think we have a good answer to that right now. I know that a lot of public officials and public health officials have been very devoted in trying to respond to this pandemic. But I think at some point we're going to take a harsh and hard look back at how we handled or mishandled this crisis, and hopefully not make the same mistakes the next time around. So this is all very real. And as I said, I know that many of you folks are dealing with it on an everyday level. And we've certainly experienced our share of the fear and the heartbreak from this pandemic on our side of the ocean. I wish for all of you a much better situation in the weeks and months to come. I hope that some of these remarks have been useful for your own work and as ways of thinking about law and policy. And I'll be happy to take any questions or comments. In addition, I sent to Kim a handout that you can request that contains a little bit of an outline of my talk, as well as some source listings of work that I've done on therapeutic jurisprudence and some of the topics that I've shared with you here today. Thank you.
Thank you so much, David. That's a broad stroke view of therapeutic jurisprudence, and I asked to come on because I also want to talk about another part of therapeutic jurisprudence, and maybe I'm not even sure how much about this that you know, but it's the part that I've been most involved in, and that's the problem-solving court model and how therapeutic jurisprudence supports that model. And so, you know, as you were talking, I was thinking about sort of the foundation of that is like, how can courts be therapeutic? And these started actually in I think 1989 in Miami, Florida, and our dear Bruce Winick, who is one of the founders of TJ, was living in Miami and was one of the people who provided guidance and support for the judges who were starting to explore this. And I actually was lucky enough to have interviewed Bruce and all of the judges that that he worked with a number of years ago, and so to hear the stories. But the idea was that that drugs, they started with drugs. Drugs were a social problem, and the courts were having to deal with them. And I remember Judge Jerry Beth Cohen said, they keep asking me to be a social worker and then criticizing me when I'm a social worker.
Yeah.
And so they started designing this, and Janet Reno, who later was in the Clinton administration, was one of the people who was involved in this that I didn't interview. But they started looking at how do we apply the science of addiction to these courts and bring a therapeutic healing approach to the courts, and how do we support the sobriety instead of punishing the addiction, the addictive behavior. So that in the problem-solving courts, the judge becomes, I sometimes refer to it as the encourager in chief.
Mm-hmm.
And so instead of punishing the person who has fallen into addictive behaviors, there's a team that is that comes around the person who is there either for possession or committing some crime as a result of drugs. So the team comes around that person as a support structure. And, how do you get a good job? How do you stay sober? Are you attending meetings, or are you engaging in your treatment plan? They want to create an environment of support. I would even say a loving environment. I know that court and love don't usually go together, but I've met these judges. And how do you create success? And so the court looks very different. People come into the court and come before the judge, and in most cases there's like the judge is the all-powerful, an erased seat and all that kind of stuff. And in the drug courts, they tend to be sitting sort of in a case management meeting at a table where everybody's at the same level. And they're talking about how to have this person be successful. The drug court program has a lot of different aspects about how people get in. Our dear friend Peggy Hora traveled around the world training drug courts before her death last year, and trained. I think she says she went to 68 countries.
Oh my gosh. I knew she was a traveler like you. Well, maybe no one's like you, Kim, as a sojourner.
She had me beat. But I don't think it's ever been done in India, and so I thought that would be a good concept to introduce here. Is that the idea that the judge is more like a coach.
Yes.
And the person comes in and they say, like part of the reality of a drug addiction is that there are times when there are relapses, and so they actually build that in, and the idea is to support the person in becoming a productive and healthy member of society, rather than putting them in jail.
Yes.
And there are thousands of drug courts now in the world. I think that drug courts have actually been piloted in at least 20 countries. I used to call Peggy before I would do a presentation and ask her, how many countries are we in now? I don't know who I'll do that for anymore. And how we approach this has had such a big impact that in some places they've closed prisons because the drug courts actually reduced the number of people who were being incarcerated And so in the early days of the drug court, that happened in Colorado and Minnesota. They actually had to repurpose prisons. I think they've found other reasons to incarcerate people since then. But
we're good at that in the United States, that's for sure.
But it's been just a really miraculous program. The people who go through actually talk about how they've that it saved their lives, and the judges become revered. I'll tell one story of one drug court judge. It was an interview that I did, and he said he was having his teeth cleaned, and the dental hygienist was crying. And he's like, what have I done to this poor woman? Or what's going on in her life? The tears are just coming down her face, and she's sniffling, and everybody's masked up and all that kind of stuff. Even then, and he finally asked her, hands out of the mouth, what's going on? And she said, it's just such an honor to serve you. You saved my sister's life.
Oh, my gosh.
And yep. He said it was at that moment that he really got the impact of what he'd been doing. And the people who become like the way the court usually works, and each court is a little different, but the way the court usually works is that instead of just having somebody come in and then say you're on probation for 18 months or whatever, the person comes back every few weeks, depending on how active their addiction is, and they come and report to the judge and say, this is how I'm doing. And so they get to know each other. And then at the end of the process, which is often about 18 months, if they have stayed clean and sober for a certain amount of time, they have a graduation. And there's there's hugging and people come. I think it was Ventura Beach, California, that had 1,000 people come to a drug court graduation. They had to run a hall because they had a big court and they had a big graduation, and people were so proud. Like, for some people who are drug addicted, this is their first graduation ever.
Yeah.
And so they're really proud, and somebody is picked to speak for the class. And I mean, for me, this is one of my favorite parts of therapeutic jurisprudence, because you can actually see the impact one by one by one. I love policy stuff, David, because that's how you get drug courts. But I wanted to bring that in just so this audience would know about them, and you may have more to say. But
Kim, I didn't want to step too far beyond my own level of expertise, so I'm glad that you have such a better ground level working knowledge of the drug courts. I did want to share something though that is going to be a little bit of an add-on to what you said. Mohammed mentioned that I'd written this article, and normally I would not, inflict a law review article on anyone, but I think for those of you who want an overview of therapeutic jurisprudence, it might be useful. The title is Therapeutic Jurisprudence: Foundations, Expansion, and Assessment, and it's an attempt to survey the field of TJ. In one handy dandy, albeit long and heavily footnoted law review article. And it includes a quote from Judge Ginger Lerner Wren, who was the first judge of the nation's first mental health court, very similar to drug courts, right? We're talking about problem-solving courts that are serving as these alternative venues for resolving disputes in a healthier and more healing way. And I just wanted to mention to really, I think, reinforce how much of a difference these types of courts can provide. With apologies for reading, Judge Ginger Lerner Wren provides a personal look at this role of judge in a problem-solving court in her recent book, recounting service as the first judge of the nation's first mental health court, founded in 1997 in Broward County, Florida. Within her first year, she began to understand, quote, the depth of emotional pain and desperation of many of the families who came to court seeking help on behalf of loved ones who were ill, unquote. This in turn informed how she would manage her judicial practice. And I just want to read a quote that I think applies to drug courts as well in the broader kind of painting of things. And this is what Judge Lerner Wren said. I understood that to humanize justice, court proceedings needed to feel welcoming and hopeful. My goal was to create a sharp contrast to how court process typically was experienced by articulating a warm welcome and by explaining the concepts and principles of psychiatric rehabilitation in simple, easy to understand terms whenever possible. The mission for a court of refuge would be to leverage the law to reach a therapeutic outcome. And that really fits with what a lot of the drug courts are doing too, right? They are saying, and if any of you know America's history with drug laws, you will know that this is a radical change from our very unfortunate drug policies of decades and decades of just throwing people in prison for having an addiction, basically, right? So I just wanted to add that quote because I think it dovetails perfectly with how you're describing the role of these drug courts, Kim. And you, our late friend Peggy, and others are among the acolytes for this type of reform around the world. And I know we have a lot of law students in our midst for this talk. And I'm just going to say to you the same thing I've said to students in a course that I started teaching that Kim guest lectured in a couple of weeks ago called the Law and Psychology Lab, is that you're being given a really neat, cool gift to be exposed to these different modalities of practicing law and applying the law that you're learning through this series and through your own work, because you can be part of the vanguard of the next generation of change to make the legal profession better, servant to the people we're trying to serve, to make the application of law healthier, to make the substance of law healthier, and also to be happier as a lawyer, which I'm sure many of you have thought about given some of the challenges we have in our own profession about morale and mental health. And so much of Kim's work has just been embracing this model, for years. I mean, Kim is one of those folks who has been ahead of the curve for a long time, as well as so many of the other writers that you may have been or speakers that you may have been exposed to in this series. So in any event, I just think that those of you who might be looking around at the status quo and saying, something, it's not quite what I would like to see it to be. It's not what it should be. As frustrating as perhaps as disappointing, maybe even as angering as that might be to see the status quo, you have a chance to be part of that wave of change. And when you can fashion as part of your vocation that kind of contribution, then you're part of something that's just much bigger than all of us, in that where the sum total of those efforts start to make a difference. So I'm sounding a little bit like a cheerleader here or a salesperson, but I've seen this as in terms of what these different alternative modes of practice can be about. And it's all about positive change. It's all about positive change. And it's about living a better life as a professional in a profession that needs, this kind of help. So that is my sales pitch.
That's so great, David. You're actually describing a lot of why I took on and being the advisor for this series, because I want people to know that one person can make a difference, and that collectively we can actually change systems. And so I want to expose people to these ideas. And when you were talking about Judge Ginger Lerner Wren, I just want to tell a little of the story about her as well. She actually started out as a real estate lawyer, and so we don't think of real estate lawyers as people who are human rights advocates, but she was always a human rights advocate. And so when she came to the bench, she immediately began to make change around the area of mental health, and now she is she's one of the leaders in this problem-solving court movement. And I'm glad you mentioned the mental health courts, because I wanted to actually mention also that from drug courts, this whole movement grew so that it's for drunk driving, people who are homeless, veterans who are returning from war with challenges related to their service. Let's see, just pretty much any problem that affects a community. The father's not supporting guns. Like there are lots and lots of courts that people have said, like, this is a community problem, and how can we address this in a way that we're not just locking people up?
Yes.
And so,
exactly.
And it was, and in most of those cases, there was just one person who said, well, I think it can be different. And so these law students can take inspiration from them and look at, well, what is it that you would like to have different?
Yes.
Or lawyers who are listening, what is it you would like to have different? And, there are other people out there who probably agree with you. And one of my joys in life has been connecting those people with each other around the world. So.
Yeah, Kim, I hear you on this, because sometimes you just have to be the one to decide to do something, right? To just say, okay, I'm not 100% sure of myself here. I may not be known by anyone. I might be just starting. But I think I've got the kernel of a good idea here. And actually, Ginger was a guest speaker in my class as well, and we heard a little bit about her story. This was not somebody who was anointed an expert in mental health and the law. She became basically a self-taught expert in this by forging a path. And that's a lesson, because I think, at least in the United States, we've become so obsessed with credentials and degrees and all this kind of stuff that some people think that, well, you know what? I don't know if I have enough training or, some kind of authority to do something. But a lot of the changes that we've seen in these so-called alternative modalities of law and practice have been people who just had the kernel of ideas and decided to do something about it. Another great example is that of Lenore Walker. She is not a doctor, she is a psychologist. But as a young therapist, she began to see the scourge of what happens with domestic abuse. And at times, there were instances where mostly women had defended themselves in these violent, abusive relationships in ways that ended up killing their spouse, killing their husband. And they would be defending themselves on murder charges. And it was Dr. Walker who fashioned what we now call battered spouse syndrome as a legal defense for those who perceive their lives to be in danger because of this constant abuse and battering and violence. And it was, and she did it as a young practitioner. She just started to put the pieces together, and she said, I'm talking to all these women about their abusive relationships, and at times some of them are reacting to defend themselves. They're the ones who are getting hauled into criminal court. And she said, you know what? I think there is the basis of a legal defense here. And she didn't do it with any peer review research studies or anything like that. It was based on the ground knowing of these women and their situations, and putting those pieces together to say, there's a common thread here, and it includes the psychology of violence and what happens when you're the victim of violence over and over and over again, and that feeling that you are trapped in something that you cannot get out of, and that may end up in you losing your life eventually. And she fashioned, it was then called, I guess it was called Battered Woman Defense, but now it's been made a little bit more generic. But it's about abuse of power, and it's about trauma. And she did this in the late 1970s and the early 1980s, when the dialogue about this kind of stuff was very different. So again, she was not identified previously as some kind of like a superstar therapist or anything like that. She saw a problem, she worked with people, she addressed it. And even when she wasn't quite sure of herself, she pushed herself to go forward because she knew there was something there. So anyway, that's another example from another field of someone who pioneered something very meaningful, with a lot of self-initiative, and in some cases, some things falling into the right place. But spiritually speaking, I've found out that if you keep going in that direction that is sort of calling you, sometimes things just fall into place in ways that you couldn't have imagined before that. And so, you just kind of listen to that, where your energy is taking you, and it can lead to connections that are sometimes life-changing.
That could be a really long conversation between us, David. I have so many examples of that. But people don't know my early background. I came from a family of, we grew all our food. We lived in the country. Nobody in my family had ever gone to college, much less to law school. And I was practicing in a town of 5,000 people in rural North Carolina when I started my journey. And it was not predictable. It was not predictable at all. But I had that sense of purpose.
Yeah.
I used my small community to experiment with some ideas. And when I saw they could work there, I said, well, if it can work here, it can work anywhere. And I started looking for my kindred spirits who were doing law a different way back in the 90s, and have now created this community of people who are change agents around the world.
Yes. And that can be all of you listening in to this little webinar.
Everybody.
Here. That's the opportunity, and you don't have to follow our path. You can make your own, and make change in ways that some of us haven't even thought of yet. So that's always so exciting to me, because all the things I haven't thought of yet that are starting to happen. Like a few years ago, we had a speaker series on this, like the idea that a contract could be a cartoon, a comic, would have just been completely silly, and now that's a trend around the world, and so I don't know what's coming next, but I'm really excited about it. Yeah, we, the things seem so challenging right now. And from that, we have to develop some opportunities for change, right? That's the option is to let the not so good directions take hold, as opposed to trying to seize that and change that direction, and to change paradigms. And if you are blessed to have an opportunity to get an education that can be very powerful in a good way, then you also have a chance to be part of a wave of change consistent with your own beliefs and values and the things in your life that you think are important.
I like to say that we're actually creating the new legal system.
Yeah.
Systems theory shows us that systems grow, decline, and die, and that they're I call it compost for the new system. And the things that are not working help us see what would work better, and we're creating the new system that is going to be on that therapeutic kind of paradigm rather than the punishment paradigm.
Yes, and Kim, I'll say, at least for the U.S., compost is a kind word. I would refer to some of it as manure, but in any event, it does give us opportunities to say, hey, we've got some different ways of doing things, and I know that's what this series is all about. And I hope that, especially for those of you who are sitting there, thinking, what will this have to do with me? Maybe you haven't identified certain areas that are things that you might want to focus in on for the long haul. But maybe someday, years from now, some little kernel of this speaker series will just pop into your head, and then you'll go, oh, that's what they're talking about. And then you're on your way. So, absorb what you can of this now, file some of it away, take some notes, keep a folder, whatever, because I think for many people, the realization of the need for change may come a little later after you've seen what the status quo of the law and legal practice are all about. I know that a lot of folks who discover therapeutic jurisprudence are folks like me who discovered it in mid-career because it helped to frame an understanding of things that we had known sort of experientially, anecdotally, and then you get frameworks, right, that help to let you know that, okay, you're not imagining things, right, and that there are some systemic problems, but there may be a road to some systemic solutions. But it is after kind of a process of observation and experience sometimes. And if you're like me, I consider myself a very late bloomer, very grateful that I have sort of this perspective that I have now. But even 20 years ago, I didn't have that kind of frame inside of me. So I hope you get it earlier than I did. But, as I tell people, the 8th grade was 20 of the best years of my life. So in any event, I know that many of you folks will be more on the ball than I've been. I think Mohammed's kind of, is he on our screen here to tell us that?
Yes, I think we're gonna see if there are any questions, and then we can go. Oh, David, you want to take this one?
Okay, so a lot of TJ, therapeutic jurisprudence, did originate around the intersection of criminal law, criminal justice, problem-solving courts, and mental health and disability law. A next generation of TJ work is applying to civil law. For example, the discussion that I had about my work in employment law. There is a huge opportunity to apply TJ outside of the criminal justice context. And excuse me, the article I mentioned surveys some of the fields of law on the civil side that are just waiting for more attention, such as family law, environmental law, trusts and estates law, everyday areas of legal practice that nevertheless can benefit from this lens. In my field, employment law, absolutely. We know, for example, that the social science data verifies that healthier workplaces result in more productivity, happier workers. So why shouldn't the law promote that? So that's just a little snapshot example. But yes, there are tons of potential applications of TJ to civil side law. And that article I mentioned, which you can access from my social sciences research network page, will give you some of those examples.
I can add a little bit also to that, because I think that the work of collaborative law sometimes falls under the TJ, and collaborative law is used mostly in divorce, but also in things like probate. I have friends who are focused on working with people who are dying, and they do things like trusts and estates and things like that. But the therapeutic part of their practice is actually really being informed about how people avoid or embrace the topic of death.
Yes.
And so that's another example. And of course, at some point we'll do a call here on trauma informed law, which is a book that I just co-authored, and pretty much there is trauma in all areas of law, even tax. We were joking that, well, maybe tax has no trauma, and then somebody who practices tax law was telling us, oh no, it's terrible, because people are crying, and often they're in tax problems because somebody died, or they've had a business collapse. And she said that she actually chose tax as her area because she thought there was no emotion, and it's a very emotional area, and that people feel very traumatized by even having an audit. And so in all areas of law, trauma exists, and therefore there's the possibility of taking a more therapeutic approach.
Yes. Virtually every field that I can think of every field of law can benefit from these various insights, such as TJ, collaborative law, integrative law. You'll see a bunch of different labels, but we're all playing in the same sandbox here, basically. And that gives you the opportunity to sort of pick and choose from things that are most relevant to you. What are the main sources of therapeutic jurisprudence? Are you talking about kind of academic resources, writings, and so forth? The article that I mentioned that I authored cites to most of what I call the foundational therapeutic jurisprudence writings, and you can trace basically by following footnotes what those sources are. As I mentioned, David Wexler and Bruce Winick are the co-founders of TJ. They have been, Bruce passed away 10 years ago, but both of them have been prolific writers, as well as Michael Perlin, some other early pioneers. If you do look at that article I wrote, you'll see some of the same names popping up over and over again. And then you have new folks in this broad realm, folks like Kim, folks like me, popping up as sort of like next generation, even though we're all not all that young, frankly, but at least next generation compared to the founders. And you'll see what some of the core documents and core law review articles are.
I also will point out, I have a YouTube channel. The channel is called Cutting Edge Law, and the interviews that I mentioned with Judge Ginger Lerner Wren and Bruce Winick and Judge Peggy Hora are actually there, and they were made almost 10 years ago, more than 10 years ago. I think the newest one is 10 years old, but they're over 10 years ago. So you can get some of the history from the people who were making history while it was still fresher.
Yes. And there are fields of law that really do need that foundational work. And it does. And I apologize for touting my own article here, but it was meant to be a broad survey of therapeutic jurisprudence, the first one that's really been done since in like 20 or something years. And so that's why I would say, to answer the next question, trace the footnotes in my article, and you will find what I call the core writings of early TJ work. And then you're going to see a much greater diversity of names and perspectives from what I call those next generation writers. So trace the footnotes in my article. That's where you'll get to some of the really good reading that may lead you directly to sources that are on your particular area of interest. And also you can email me for suggestions as well. The International Society for Therapeutic Jurisprudence, which you can Google, has a freely accessible website database of TJ related articles as well, that you can just type in your interest area and see what comes up.
And Nabila, who is part of our community here, actually has started a chapter in India
That's great.
for
Yeah.
ISTJ. And so you can make connection with her as well. So
I think
Are there
I
other-
think we come to the end of the session. So, ma'am, yeah, I would really like to express my heartfelt gratitude to both of you for really taking us through the course of this session. It was really brainstorming, and it gave the audience a very different perspective as to how to understand jurisprudence itself. So I think thank you so much for joining here with us. And although you're present in US, I think virtually being present in India at the moment.
I wish for all of you much safer days, and I know people are really struggling right now with the current situation. So thank you again for inviting me to join you. It's been a real honor and a privilege, and I hope that some of the ideas that Kim and I have discussed give you reason to get excited about the lives that you can live and the differences that you can make.
I'm holding you all in my heart. I do have my dear friends in India that I'm keeping in touch with, and getting information about really how serious it is. And so thank you for taking the time today, and especially you, Farhan. I hope that your family is all well.
Yes, ma'am.
David, thank you. Thank you for
yes,
joining us.
My pleasure. And I reversed, Farhan, I reversed your last names and your first names. I apologize for that. I was reading from the screen. So let's see. I guess I'll just say goodbye to all of you. And
Yes, sir.
again, you have my my contact information. You can Google my name and get my email. And again, Kim has a copy of the one-page handout that I put together. And other than that, I think you folks can continue your conversation, and I'll hit leave, right?
Yes, sir.
Okay.
Thank you so much.
I think we'll all leave.
Okay, Farhan.
Thank
Again,
you.
thank you, Kim.
All right.
Thank
Bye.
you. Take care, everyone.